Your Lordships recall, Millets, that this is a matter where previously the matter came up before Your Lordships. The matter travelled all the way up to the Honourable Supreme Court. The Honourable Supreme Court, Millets, then took a view, gave the government the ability to segregate pre-88 FDCs. Millets left it open to them to take a view on whether they wanted to examine them. Pursuant thereto, Millets, a committee was constituted. That committee ultimately has made some recommendations. Those recommendations have ultimately been acted upon, resulting, Millets, in the impugned order. It is our case, Millets, as petitioners, that the mandate of what the Honourable Supreme Court directed has not been complied with. And in any event, Millets, the statutory mandate is not to ban. The statutory mandate is, Millets, to have a graded response, with the ban being the ultimate response in an appropriate case where the public interest is so overwhelmingly large that the product, Millets, need not be there. Your Lordships will permit me to start with the impugned order in the first place, and then, Millets, work backwards from there. Please straight away have, Millets, the impugned notification. Your Lordships will find that at page 40, and the English version at the bottom of that page. Which file number? Millets, I would be referring to item number. That the rate will be. Millets, this will be item 41. On a lighter note, Millets, since it is title is elaborate, Your Lordships will permit me to elaborate. No. Please elaborate. Lordship sees, Millets, the documents. Your Lordship, Justice Narula has them. Yes. Whereas the central government, in exercise of the powers conferred by Section 26A of the Drugs and Cosmetics Act, prohibited the manufacture for sale and distribution for human use of drug fixed dose combination of flupheniramine maleate plus codeine syrup. Your Lordship will find codeine and codeine phosphate used interchangeably. Within notification number 909, published in the Gazette of India, dated so and so. Whereas in light of directions given by the Honourable Supreme Court in its judgment dated 15th of December 2017 in the case of the Union of India versus Pfizer, in appeal number so and so, mentioning that in respect of 15 FDCs, just mute. Yes. Mentioning that in the case of, in respect of 15 FDCs claimed to be approved prior to 1988, the central government, and please note, may, if it so chooses, de novo carry out an inquiry as to whether fixed dose combinations licensed prior to 1988 should be the subject matter of a notification under Section 26A of the Drugs and Cosmetics Act 1940. Matter was examined by an expert committee constituted by the Government of India, which furnished its report on the 1st of April 2022. And I make no comment because of that date on the quality of that report. In respect of the above, drug to the central government and the Drug Technical Advisory Committee Board, constituted under Section 5 of the Drugs and Cosmetics Act, agreed to the report submitted by the expert committee. And whereas the expert committee recommended that there is no, please note, therapeutic justification for the ingredients contained in this FDC. Lordships will note, Millets, that the individual components are not banned.